Mr. Brock, go ahead, sir.
Chair, thank you, gentlemen, for your attendance today. I'm going to share some of the comments of my colleagues in terms of some of the overlap between McKinsey and Government of Canada strategies, also known as GC strategies. And in terms of the focus of the documentation, which in most cases on both sides of the equation were often missing, incomplete, altered after the fact, it really begs the question, and this is something I get continuously and daily from constituents from all across this country, right, is who is actually responsible for this? It's one thing for us as parliamentarians to expose the rot and the corruption in this government, in this broken procurement process. But where are the consequences? So that's going to be the focus of my first round with you. And the consequences, in my view, ought to be criminal in nature. Because you have a mandate, Ombudsman, I know you do. You mentioned that during your last appearance at OGO, that if you uncover elements of criminality, and I believe your threshold is a mere suspicion of criminality. Am I correct in that assessment? A mere suspicion of criminality?
So there is nothing formal in either the legislation or regulation in regards to criminality. Okay. However, that being said, if we were to see something that would give rise to a suspicion of criminality, we would refer that to the RCMP.
Sure. And your threshold is the lowest rung of the ladder in terms of ultimately until you get a conviction. There's suspicion, then there's reasonable and probable grounds by a police service, then there's proof beyond a reasonable doubt by Crown attorneys, and ultimately a conviction. So a suspicion is a very low threshold. I'm looking at literally the same sort of criminal charges as it relates to McKinsey as the Government of Canada strategies, who the RCMP have confirmed and have raided his house a couple of weeks ago. They're looking at 2 counts, fraud under Section 380 of the Code and forgery under Section 267 of the Criminal Code. So I know that you may not be comfortable in answering this question, but I'm going to put it to you in any event. Do you feel, given your review of McKinsey and the irregularities and the strong presumption against a favoritism towards McKinsey over any other contractor, that there is an element of fraud in relation to the Government of Canada? Yes or no, sir?
You always ask me these difficult questions with only yes and no options.
If it's not a yes or no, I'll allow you to expand.
So I would say no. In this circumstance, what we did see is we saw a bunch of different reference points across different departments, and that's why you see in our conclusion we say in some, right? So within any given department, we didn't see 10 examples of favoritism, right? The only example of communal favoritism, I would say, was in the creation of the National Master Standing Offer, right? It offered an opportunity to contract in a unsolicited way, so where it's directed to McKinsey on a repetitive basis. And so that would be what I would identify as the singular most problematic aspect of this review.
Are you familiar with the definition of fraud under the Criminal Code?
Yes.
Okay. Everyone who by deceit, falsehood, or other fraudulent means defrauds the public, in this case the taxpayer, of any property, money, in this case taxpayer funds, or valuable security or any service, if it's over $5,000, proceeding by indictment and imprisonment for 14 years. So favoring one particular company, allowing them to egregiously break the procurement rules in non-compliance of numerous statutes, numerous regulations, numerous policies, and in fact the PSPC themselves published a document calling Doing Business with the Government of Canada, where they highlight openness, transparency, and accountability. In all those circumstances, do you not see a low threshold case of making out that the Government of Canada, through the PSPC and other departments, are defrauding a taxpayer by favoring McKinsey over other legitimate vendors?
Right.
Could an argument not be made, sir?
And that I have to ask to be a yes or no because we're out of time.
Could an argument be made? Yes. Did we see it? No.
Thank you.
Mr. Genuis, please go ahead, please.
Thank you, Chair. It's great to be back at OGO after an unusually long hiatus. And Mr. Jiglick, thank you for the incredible work you're doing on behalf of Canadians, bringing to light these various significant problems in our procurement system. Your report talks about favoritism in terms of the government's treatment of McKinsey, how they favored McKinsey, how they structured systems in order to give contracts to this favorite consulting company of the Prime Minister. McKinsey benefited from this favoritism. And based on the previous work of this committee, it's clear how this happened. Dominic Barton was brought in to chair the Prime Minister's Growth Council at the same time as he was the managing partner at McKinsey. McKinsey analysts did so-called pro bono work for the Growth Council. Andrew Pickersgill, who ran the Canadian operations, supplied the analysts to do the pro bono work. But while he was supplying McKinsey analysts to do supposedly helpful pro bono work for this Growth Council that was chaired by Dominic Barton, he was also selling to the government. And so you have this process where Prime Minister Justin Trudeau and Dominic Barton are kind of making this connection at the top between McKinsey and the government of Canada, and then that is clearly filtering out over time throughout the whole system, where the connection at the top was shaping and impacting the kind of procurement that was happening across government to work to the advantage of McKinsey. That led to the establishment of the National Master Standing Officer. I want to ask, just in terms of the analysis you did, about specific individuals involved and what roles they played in getting these things established. So could you speak to Dominic Barton and Andrew Pickersgill, for example, and where they showed up along the way in terms of looking at how this favoritism manifests itself?
Mr. Chair, thank you for the question. So in our review, those names, to my knowledge, did not come up. I'll look to Derek just to confirm, but my belief is that those names did not come up.
I can confirm that Dominic Barton's name did not appear. Andrew Pickersgill, I'd have to go back and review their documentation, but I don't recall seeing that just off the top of my head, but I can come back to you with that information.
Okay, if you could provide some follow-up information in writing about some of the specific individuals. I'm not at all surprised in the sense of Dominic Barton, because I see that connection having been made at the top between the Prime Minister and him, but the selling process happened by Andrew Pickersgill bringing in these analysts. It was the relationship that happened at the top between the Prime Minister and the leadership at McKinsey that then allowed this favoritism to take place. We know as well that there's been a lot of kind of interplay between senior Liberal offices and McKinsey. There's a former member of Parliament in the government caucus that was a former manager at McKinsey. We've had former staff members from the government go to work for McKinsey. What kind of information were you able to identify around sort of political involvement, decisions made by ministers, by ministerial staff that were part of this sort of broader culture of favoritism for McKinsey?
Mr. Chair, thank you for the question. So in the report, we found one example of where a minister approved a contract. It was an ESDC contract. I believe the question came up before you entered the room. But essentially what happened in that circumstance was it was as a result of an internal delegation document within the department that required that contract due to the value to go to the minister for approval. So that was with Minister Tassi for approval. But that would be the only example in our report where we saw any action on the part of a political actor.
Okay, thank you. One of the other issues that frequently comes up with McKinsey is questions of conflict of interest, how McKinsey works for governments and then also works with people who deal with governments. For instance, they work for health regulators, and then they've also famously, tragically worked for certain manufacturers of opioids. In your work, did you see clear instances where they were doing work, for instance, for Health Canada, for other entities in government, where they were also working for companies that the government regulates? I appreciate, part of the difficulty is they have not been willing to give even this committee a client list when requested. But were you able to identify instances of those kinds of conflicts?
Mr. Chair, thank you for the question. So I can answer no, but that's because we weren't looking for that specifically.
Well, just in the time I have left, I just reiterate how important it is, and I think there hasn't been the agreement that I would have hoped for in the past, but how important it is that this committee gets the documents that it had previously requested. There previously had been agreement to order, and we hadn't been able to get in the past.
Thank you, sir. Comment. Mr. Brock, please.
Thanks, Chair. Mr. Yeglich, we finished off my first round discussing fraud. I want to talk now about forgery under Section 366 of the Code, which is defined as anyone who commits forgery by making a false document knowing it to be false with intent upon conviction could be looking at a prison sentence of 10 years. Making a false document is defined in the Code to include altering a genuine document in any material part, making a material addition to a genuine document or adding it to a false date, making a material alteration in a genuine document by erasure, obliteration, removal, or in any other way. In your report under Section 110, paragraph 110 of your report, you talk about a number of observations that were creating a strong perception of favoritism towards McKinsey. 110 sub C talks about the inappropriate reevaluation of bids resulting in McKinsey deemed the only compliant bidder and awarding the contract. To an individual parliamentarian with some legal background, I view this as taking an original contract of so many different qualities to that contract and manipulating the contract so that McKinsey, in essence, becomes the successful bidder. In my opinion, sir, as a former Crown attorney, a case could be made out for an element of forgery in relation to that practice. Would you agree with that, sir, that that could be the subject of an RCMP investigation?
Mr. Chair, so I can't definitively answer yes or no to the question because the fact set is a little bit more complicated than what's kind of portrayed here. So essentially, why we made a negative inference in this specific circumstances, this specific file had documentation at all steps of the process except for the point in time that this is identified where the decision of the evaluation committee was sent to the to the contracting authority. The contracting authority performed the financial evaluations. The results of the financial evaluations were then made known to all the evaluators. It was at this point in time that one of the evaluators saw who the ultimate winning proposal should be. Now, at that point in time, there's no further documentation as to what happened. Ultimately, it was indicated by that specific evaluator that there had been an error in the assessment of one of the criteria associated as part of the technical evaluation. In their opinion.
Which could in essence be a material, excuse me, a material alteration of that particular term. So I'm not asking you to agree with me. I'm just saying, could a case be made out, sir, for investigation? In much the same way you agree with me with respect to fraud.
Right. So.
Right. Okay. I'll move on. I understand your office is also investigating the concept of bait and switch across all federal departments. Is that correct?
So, Mr. Chair, just to clarify, that was reported to the committee that it's something we found reasonable grounds for. As you'll remember, it is a funding issue for our office, so I have put forward a funding request to the department. So pending funding, yes, that is something that we intend to pursue.
If you pursue it, if you undertake it, that in of itself could reveal criminality, correct?
Potentially.
Right. And if you do receive the funding and the approval to proceed, would the bait and switch investigation also include, in these circumstances, McKinsey in much the same way you investigated the Government of Canada strategies?
So, Mr. Chair, I think it is possible that McKinsey contracts are captured by the bait and switch now.
Thank you.
Okay.
Thank you. In your review of the McKinsey contracts with the Government of Canada, did you uncover any evidence of the destruction of documentation that was prevalent throughout the GC strategy investigation?
Mr. Chair, so we didn't see a prevalence of document destruction. We did see, as you noted, that same file where there was an offer to delete a document associated with the financial evaluation, but that would be the only example that I could think of.
I quickly want to get one question out. You talk about a lack of oversight, particularly by the PSPC. Are you in a position to file at a later date all of the individuals who worked at PSPC and CBSA, in fact, all the departments that you reviewed, who are responsible for their involvement with McKinsey and allowing this misuse of taxpayer funds to occur? Can you give us all the names, sir, within those departments?
So, Mr. Chair, what I can do is I can provide you the names that were captured in the documentation that was provided to us.
Thank you.
Thanks very much. Mr. Sousa, please go ahead.
Thank you, Mr. Chair, and thank you both for being here. It's very important work that you're doing. I mean, we all recognize that we have to do better. It's been decades. It's not just the government of Canada. It's all levels of government. It's prevalent throughout industry. It's prevalent in other jurisdictions around the world. And I think you can speak to some of that, and we would welcome your comparison as to what's happening here and what we are doing now to try to overcome those challenges.
Mr. Genois, please.
Thank you, Chair. So we've established that this government had a structural favoritism for McKinsey in terms of their contracting. That exists in a context where, and when we've discussed it at this committee, some of the real horrific abuses that have happened at the hands of McKinsey, advice related to supercharging the opioid crisis, advice on how to identify influential dissidents of the Saudi regime, some of the state-owned companies in the PRC that McKinsey did work for, continuing work for the government of Russia following the initial invasion of Ukraine in 2014, advising employees about not participating, for instance, in pro-democracy activities in Russia. So there's many of these different issues. And so I'm grappling with this reality of deeply unethical behavior by McKinsey, and at the same time how they were favored by the government of Canada. Did you look at all at sort of the relationship between ethical conduct and favoritism for a company? It's one thing for a company for decisions to be made about a company being excluded or not, and it's a whole other thing about the company that behaves in the way McKinsey does actually being favored by the government of Canada.
So, Mr. Chair, none of the lines of inquiry actually looked at the ethical behaviors of McKinsey.
Okay, could you comment then on the integrity regime system in particular? Do you think there should be a blacklist? Do you think there could or should be a process whereby, in the context of procurement, officials are looking at the nature of the company they're dealing with and whether it has the kind of values that we would actually want informing advice in government? Do you think that's something that could or should be built into a procurement process?
Mr. Chair, absolutely. I support an integrity and a strong integrity regime where that is something that's contemplated. It also goes hand in hand, and I hate to sound like a broken record today, but it goes hand in hand with the vendor performance management framework as well, because the regime that you refer to kind of speaks to criminal investigations and ultimately convictions and what the implications would be to those suppliers. What I'm talking about is even more broad, is that if, for example, a company promises to deliver something by a certain date and doesn't deliver, I would still argue there's an ethical component to that. And where they haven't delivered, there should be a consequence to them. So I support what you're suggesting.
Thank you. And of course, you're looking at the government of Canada, not at McKinsey. So you're not evaluating their ethical conduct. You're evaluating the government's approach to procurement. Were people in government asking these kinds of questions about McKinsey? Was that sort of part of the thought process or the deliberation that was happening, or was that not on the table or on the radar screen at all?
So I'll answer to the best of my knowledge, and I'll ask Derek as well. But to my knowledge, we didn't see anything in the documentation speaking to the ethics of McKinsey & Co. But I'll let Derek confirm.
I agree.
Thank you, Chair